Joining us now, ladies and gentlemen, boys and girls, children of all ages, Adam Thompson, defense attorney, our friend. Hello, Adam. How are you? Hi, Adam.
Hey, Steve. How are you?
Good, good. Thanks for taking the time to be with us today. Closing arguments. So we'll get to everything else that happened in court. But closing arguments by the prosecution. Phase one, of course, defense goes tomorrow. Then the prosecution gets to finish up. Then it goes to the jury. Let me ask you this. Yesterday, we saw the prosecution use that dummy and bring up to the jury that, hey, Trayvon Martin might have been on top. You know, and now today they said, yeah, Trayvon Martin might have slugged George Zimmerman in the face at first in a fight for the gun. So all of a sudden, you know, after the whole premise is that Trayvon was on the bottom screaming for help and that George Zimmerman attacked Trayvon Martin, hunted him down. Now, yesterday and in closing arguments today, respectively, they present what I just said to you, the possibility that Trayvon was on top, and that Trayvon might have hit him first in the face, going for the gun. So, is the defense going to make mincemeat out of that tomorrow?
The defense is going to crucify them. Let me tell you, that's like going to the movies and you're going in to see Star Wars, and instead you see Jurassic Park with dinosaurs. You can't change your theory of the case so dramatically where it counteracts and counterspeaks everything that you initially talked about in your opening argument. How do you go from one to the other? I mean, listen, like I said from ages ago when we first spoke about this, they're not going to get conviction on murder 2. They're not going to get a conviction on manslaughter. No matter what they do, listen, Humpty Dumpty fell and broke. No matter what they do, they can't put the pieces back together. Changing the stories around, the theories, whatever they're going to try to do at this point to make it fit, too little, too late, and the jury is going to see through all of that after the defense closing.
All right. Well, I hope you're right. I don't understand why. I mean, I guess they realized, and you tell me, I'm just putting forth a theory, a non-legal theory, just an opinion, that they realized they were in trouble. They realized that the preponderance of evidence did not back up what they had claimed in their opening arguments, and that the jury wasn't going to buy if they said, well, now we've proven that Trayvon Martin was on the bottom screaming for help and he was hunted down, and so they had to change their story. I mean, is that the explanation?
That's the best they can come up with. They have to have something to say. So when there's nothing else to say, you go with what the facts on the table are. I mean, it's really embarrassing for them because think about it. They did a very bold opening. Everything looked good for them. Because remember, after the openings, you heard a knock-knock joke from the defense,
right,
which was a disaster.
Right.
And you heard this impassioned, emotional opening from the prosecution.
And by the way, all we heard was the prosecutor looked like Gregory Peck, and the women on the jury just couldn't take their eyes off of him. This case was over right now.
That was it. And then what happens? Well, openings are nice, but they're not evidence. It's just, the lawyers anticipating what they think will happen at the trial. It's a lot of flash and dash sometimes and some theatrics and emotions. But when it comes time to the actual case, when you're presenting the evidence, the testimony, the tangible things you could touch and feel, DNA results, experts, that's the nitty-gritty. And what happened? When they got to that part of the case, it collapsed real fast. It was a mudslide that just picked up steam.
All right. They did attack, though, in their closing arguments, George Zimmerman as a liar, as a wannabe cop who knew he had a gun and was going to take care of this on his own, who, followed him and lied and lied and lied and changed his story and lied. And yet, the defense comes back and says, well, you heard from expert witnesses saying that the discrepancies in the stories are normal. They were nominal. They were not out of the ordinary. I just think everything that was said today presented in such a, I don't know, I guess a typical prosecuting way, can be the defense with Mark O'Mara at the helm in a calm, as is his demeanor, in a calm manner, which appeals to the all-female jury, could just go point by point and dispute every one of those claims.
Absolutely. Listen, they could take the timeline, go through it to show how it fits their case. They could go through the main witness's testimony, and it supports the contentions of self-defense and Zimmerman's versions and all the different statements that he gave. But I think, and I don't know what they're going to do yet, but if it was me, doing this for 25 years, I'm a very aggressive attorney. I would basically make a flow chart of the opening statement of the prosecutor and say, remember when this case started?
Right.
The prosecutor made certain promises to you. This is what he told you this case was going to be about. And this is what he told you the evidence was going to show. And did they deliver? Did these things come to fruition? And the answer is no. Did they tell you in an opening argument that their two main police officers were going to say they found Zimmerman credible and they believed him? No. Did they tell you how their expert who was going to talk about the medical autopsy was incompetent and didn't remember zero? He put up a goose egg with his own hand and went zero. I don't remember a thing.
Right.
When you go through all of this, and then let alone the big one at the end, and here's the finale. Let's, strike up the orchestra music for the grand finale, and we're going to change our theory at the end from Trayvon Martin was on the bottom screaming for help, getting assaulted and then shot, to guess what? He's on top of Zimmerman now, maybe hitting him and doing a ground and pound, but then something happened. Really? Really? You're changing it like that? Come on.
We're talking to Adam Thompson. We only have 3 minutes left, so I'm going to ask you two questions. One, Rachel Gentile, I believe the prosecution invoked Martin Luther King about, don't go by her race or whatever, go by, and he admitted she lied on oath under oath in the past. You know what I'd say if I'm O'Mara? All right, believe her. Believe her when she said that Trayvon Martin viewed him as a crazy ass cracker. Not as some guy he had to get away from, but as in a hostile, racially hostile manner.
There's two sides to every coin, and I'm sure they're going to bring that out. But I would almost attack that to say to inject race. I found that personally to be very offensive, that he's quoting from one of the greatest speeches ever gave.
Oh, absolutely.
And applying it to Rachel Gentile, who was a disaster on the witness stand and had no credibility, and basically saying, she was pounded upon by the defense because it's a race issue. But don't look at her for that. I have a dream that all witnesses will be treated equally and all witnesses will be based on their testimony, the substance, not how they present.
Outrageous.
And that wasn't what happened at all here. The defense attorney is representing someone whose life is on the line. That's their job. And they need to cross-examine every witness as intensely as possible.
And they did it with
what everyone would want.
And they did it with respect. It was her who was so disrespectful. The judge should have told her to change or face contempt. All right, now, manslaughter. How does this defense attorney convince the jury that you can't settle for manslaughter? It's not an option. Don't do it, because you can't tell him he'd spend 30 years in jail if you convict him on that. How do you get around it? How do you tell him?
Well, depending on who your defense lawyer is, someone might blurt out, if you convict him on any count, he's going away for the rest of his life. The prosecutor will object. The judge, probably not wanting a mistrial, will probably give a curative instruction saying, disregard that you heard that. Sentence plays no part in your outcome in this case. That's all as an aside. If you have a real aggressive defense lawyer, they might take that risk, but it could lead to a mistrial. But how do you get around the manslaughter? You basically got to tell them you're here to make a decision on the case that's based on the evidence. And if you believe that George Zimmerman was defending himself, that in his subjective mind he thought he risked imminent fear of harm or death at the hands of Trayvon Martin, and that the only force he can use equal to what was being done to him was to use his firearm.
Right.
To save
Then
his
you
own life.
you got to say not guilty. Adam, I got to say I'm out of time. I hope we could get a chance to chat tomorrow and down the road. Thank you, Adam Thompson, ladies and gentlemen.
You got it. Thanks, Steve.
Thank you. I love his passion. I love